Next case on the calendar is Orange County School Board versus Hall. Counsel, if you're ready to proceed.
Good afternoon. May it please the Court. My name is Thomas A. Moore, and I'm here today with my partner Kevin Murphy, representing the Orange County Public Schools and United Self-Insured Services in a workers' compensation case filed by one Mr. Richard Hall. It is our position that the judge's order down below, finding Mr. Hall's accident and injuries compensable, should and must be reversed as a matter of law. Mr. Hall, although there's some unknowns in this case factually, what we do know is that on the date of Mr. Hall's loss of balance on the job, he was employed with the school board at elementary school, and at that time his weight was acknowledged by Mr. Hall to be 485 pounds. Before his loss of balance on the job, he suffered from significant pre-existing ailments that are listed throughout our briefs, to include serious problems with chronic cellulitis of his lower extremities, resulting in many hospitalizations and problems even up to the date of the accident. He had limitations walking, standing, and difficulties ambulating. On August 6, 2008, Mr. Hall, as found by the court down below, simply lost his balance and fell. In workers' compensation cases, and we understand that the purpose of the Workers' Compensation Act, as elucidated by the Supreme Court of the state, is to place on industry those accidents and injuries caused by industry. The Supreme Court has stated this on many occasions and has indicated that they don't want to make workers' compensation policies general health policies. So in order for a workers' compensation matter in the state of Florida to be compensable, it is mandatory that there be a compensable accident with a compensable injury. Not all accidents are compensable, as like not all injuries are compensable. It is our position, in reference to the first point in our brief, that Mr. Hall simply failed to establish by medical evidence, which is mandatory in reference to his date of accident, that the major contributing cause of his injury was, in fact, his loss of balance and fall on the job.
Counsel, did I remember correctly from the record that at several different places, pretrial hearing information sheet being one, the employer carrier conceded that the claimant's right arm fracture resulted from the fall at work?
I don't think there was a concession. I think that what we conceded was there was a fracture to his right arm.
From the fall?
Well, we're not doctors. I'm not a doctor. I can only say, and the statute does require that there be medical evidence.
But what was in, I don't have those in front of me, do you recall what was in the stipulation and the various documents filed with respect to that? Because if in fact you conceded or stipulated that the right arm of the claimant was fractured from a fall at work, why should the claimant be put to proving that very fact?
Because the statute mandates it, Your Honor. The statute mandates that there be medical evidence to support that particular finding. I don't specifically recall that stipulation, Your Honor. What I do recall is saying that he did have a fracture, and the fracture did follow a fall. But I think what the courts have to look at is what was the origin of the reason for that fall. And that's what courts have looked at historically in reference to falls on the job.
Well, counsel, in the pretrial information sheet, in fact, and I'll quote, Mr. Hall fell at Fern Creek Elementary where he was employed in technical support. As a result of this accident, he sustained a 3-part fracture of the proximal humerus. So are you suggesting that in a workers' compensation case that you can't stipulate to this fact that it must be proved by medical evidence only?
No, Your Honor. And I truly didn't recall that particular stipulation. I don't believe I did that. But I would suggest that it's clearly our position on the case and at the trial that clearly they had to establish that by medical evidence. The statute does mandate this particular proof, and it's clear throughout the record that that was clearly our position. Now, it may not have been artfully exhibited in reference to the pretrial, but I don't think there was any misunderstanding of the parties that clearly our position was that this incident does require there to be some evidence of this relationship. medical.
On the other side of that argument, though, there was no evidence presented that he fractured his arm as a result of anything except for the fall itself. I mean, you may dispute the reasons that he fell, but it doesn't seem to be that there's anything in the evidence that your client presented in terms of medical evidence that the fracture was sustained as a result of anything except for the fall. Is that correct?
Well, that's basically correct, except, again, the statute does require it has to be by medical evidence only. The major contributing cause pursuant to 440.09 has to be established by medical evidence only. And that opinion just does not exist. It's our position, certainly, that the burden of proof is on the plaintiff to prove that aspect of his claim. And Mr. Hall's, in this case, simply did not prove that particular point. Because he failed to prove that particular point by medical evidence, we suggest that the order should be reversed and the claim denied.
Don't we run the risk of sandbagging if we allow one party to stipulate to a fact and then take the position that you didn't prove the fact at the hearing later on? That's what really bothers me.
Yes, sir.
I'm not saying that's what you're doing, but it concerns me looking at this from the big picture.
Yes, sir. In all candor, to be honest, I would understand that point. I just don't think that honestly, that the pretrial was poorly worded, in fact, and I don't know if there's any evidence of any sandbagging, because I think it was very clear that that was a part that's obligated under the statute. We must remember the claimant has a burden of proving it, and that's an obligation. But I understand your point, Your Honor.
In fact, the JCC here sort of went out of his way to say that I think it was that he would have to completely suspend common sense and belief not to make a clear causal link between the fall and the fracture given the medical records.
I understand that. And unfortunately, the statute, or fortunately, I should say, for our point of view, the statute requires medical evidence. So, logic and belief or whatnot is not the appropriate standard to make that necessary link, causal link. So I understand the court's position, but the statute, the legislature's words have to be given meaning, and the statute clearly identifies that that is an obligation on the part of the plaintiff to prove, or the claimant to prove. Mr. Hall's fracture was not readily observable. And if you look at this 440.09 further, it does state in injuries in which the injuries are not, in accidents in which injuries are not readily observable, again, it must be proven by medical evidence. And it's, again, our position that they failed to prove that particular very important point. Now, it's further our contention, in reference to reversal of this order and denial of the claim, that in point 2 of our point, Mr. Hall failed to prove that there was, in fact, some occupational causation for this incident. The second prong of establishing a compensable workers' compensation claim is this proof of a compensable accident. Again, not every accident on the job is compensable. The courts have wrestled numerous and many, many times with exactly what, if an accident has happened on the job, is it compensable or is it not compensable? The fall cases have always been problematic with the courts, from the Supreme Court to this court, in determining whether there's an occupational causation for that particular event. Now, again, simply Mr. Hall lost his balance on the job and fell. That's in the judge's order. And nowhere in that order is an identification that that loss of balance was associated with any employment duties or responsibilities on his job. He stopped at a pole. We don't know exactly what his intentions were. He stated that he had different intentions, but he simply lost his balance and fell over.
But, counsel, isn't this just a question of competent substantial evidence?
Not in reference to the occupational causation. That is a legal requirement that must likewise exist in reference to make a claim compensable.
But to the extent that the court specifically found that the claimant walked over to the picnic table to speak to the principal, to the employer, and did specifically find that he was doing these things in the scope of his employment, isn't that entitled, isn't there competent substantial evidence to support that finding?
Well, in reference to that statement, there was nothing that he even got to the picnic table. He was standing in a corner resting after walking. He was tired. He looked labored. He's standing there resting. He's a tremendous-sized gentleman, and that it looked like he had moved one foot and fell over. Now, of interest, if you look at the histories that Mr. Hall himself provided in the record to various medical practitioners and to people in this case, at the hospital, when the first accident first occurred, he went to the hospitalist, and the hospitalist took a history that Mr. Hall fell while crossing the street when a brick on a curb gave way. That's an interesting history, and nowhere does that relate that his fall occurred on the job, which was occupationally caused.
So if the, excuse me, Judge. Go ahead.
Didn't the judge of compensation claims expressly find that these pre-existing conditions, that he found that they didn't bear any relationship to the fall itself, and expressly rejected that argument that was made about this idiopathic fall, and that these pre-existing conditions were in fact contributing factors?
Yes, Your Honor, they did. He did. However, I contend that evidence is only necessary if the requisite prima facie case of a compensable accident and injury is established. That's only then the burden then shifts to the employer carrier to show that there was another pre-existing cause or pre-existing problem that was a greater cause of this particular accident. And I contend that because the claimant in this case never showed a prima facie case that indicated that his loss of balance was due to his employment situation, that burden of establishing those pre-existing conditions was necessary for me to prove. I did show in the record he had lots of problems, all of which could possibly be a reason for his loss of balance, but it wasn't necessary for me to prove at that particular time. Again, Your Honor, I think that what this case really boils down to is a shifting of the burden of proof. Although I argue that he didn't present medical evidence that shows that the major contributing cause of his injury was associated with the accident, I would now suggest a stronger point in my position is that he didn't show that his loss of balance was occupationally caused, and that's a requirement under the statute. And until he presents that prima facie case, he has not met his burden of proof. And I do not have to thereafter overcome any particular proof that's presented by Mr. Hall. Because Mr. Hall has failed to meet his burden of proof in this case, I suggest that this order should be reversed and the claim denied.
Counsel, so if he tripped walking across the street, as I guess the occupational someone in the hospital wrote, you're contending that that would not be arising out of his employment, and therefore there would be no workers' comp claim here?
If it's on the street, he didn't fall on the street for which the principal observed the incident. He was on the sidewalk, in the hallway. So if he went to the hospital and said, oh, by the way, I was walking the street, and as I was stepping up on a curb, a brick gave way, causing me to fall, that could have been another cause for the fractures that he exhibited at the hospital on the x-ray. I just don't know when that event occurred.
It might have been a separate incident.
Could have been, Your Honor.
I misunderstood what you argued.
Yes, I'm sorry. Now, in reference to other histories, you've got to remember, when he spoke to the principal a couple of days after the incident, he says, my ankle gave way, causing me to lose my balance. Okay? On the same night of the hospital, when he was after the hospitalist took the history from him, he told another employee of the hospital that his ankle gave way. A few days after the accident, when the adjuster was investigating the incident, he says, I really don't know what happened. And then at the trial, if you read his testimony carefully, again, he was all over the board reference. He didn't identify anything associated with his occupation that caused this particular fall. So it's our contention that points 1 and 2 mandate a reversal and remand and denial. Because if I didn't reach it in point 1, I certainly contend that point 2 in and of itself is sufficient to warrant what I'm asking this court to do. Points 3 and 4 are pretty self-explanatory in the briefs. I think that this is a fundamental error, and therefore a rehearing is not mandated. And I cite the cases of Aridi and Francis. In reference to point 4, obviously fees and costs would not be due, because it's my contention that the burden of Mr. Hall Proven's case was not met, and thus we do not owe costs and fees in this matter. Thank you for your time. If I can reserve the 50 seconds for rebuttal.
Okay.
Thank you very much.
May it please the Court. My name is Bill McCabe. I represent the claimant, Richard Hall, and Jeff Bordoulis is sitting at counsel table. He's trial counsel. We submit the judge's finding that claimant sustained a compensable accident resulting in a compensable injury to claimant's right upper extremity is based on competent substantial evidence, is in accord with applicable law, and should be affirmed. First, claimant established a compensable accident. It arose out of and in the course of employment, which is the occupational causation. In order for an injury to arise out of the course and scope of employment, the claimant must establish two elements. First, the work must have been performed in the course and scope of employment. And secondly, the work must be the major contributing cause of the accident or injury. Now, claimant's accident occurred in the course and scope of employment based on the premises rule. He was where he was supposed to be at a time when he was supposed to be there, doing what he was supposed to be doing. He was going to be talking to the principal. Additionally, the claimant established the work was the major contributing cause of the accident. And contrary to Mr. Moore's position, the Bryant case really addresses this. It says, when the employer and workers' compensation carrier assert that an injury is the result of a personal risk, such as an idiopathic pre-existing condition, they must carry the burden of proving the existence of such condition. And only if they do in that instance, then is it appropriate to require the claimant to meet the more stringent standard of showing the employment created some sort of increased risk of either having the injury be caused or, of the accident or adding to the injury. Now, in this case, as you pointed out, the judge made a specific finding that although this claimant had some pre-existing conditions, he had no relevant pre-existing conditions, and there was no pre-existing condition or idiopathic condition that had anything to do with the fall. And they have not challenged that factual finding in this appeal. Now, if there is no pre-existing idiopathic condition, then the Bryant case also says if the workers' compensation claimant has no prior weakness or disease, any exertion connected with employment and causally connected with the injury as a medical fact is adequate to satisfy the legal test of causation for recovery of benefits.
But counsel, isn't it clear that the case law, under the case law, that not all injuries that occur in the workplace are compensable? And so when you look at the Serrano case where the worker stood up after sitting at his computer desk and the court found that that was not a compensable injury, how do you distinguish the facts in this case where the claimant was merely walking down the sidewalk before his fall?
Well, the claimant here wasn't merely walking down the sidewalk. The claimant here was stepping over a brick riser so that he could go to a picnic bench where the principal was sitting so that he could talk to her. He didn't just trip and fall walking down there. But the case that you mentioned, that claimant did have a pre-existing idiopathic condition that caused the injury. The judge found contrary to that in this particular case. This gentleman, while he was reaching or trying to get over the riser to get to the picnic bench, lost his balance and fell. That happens a lot of times in workers' compensation cases. Claimants lose their balance for one reason or another. The injuries are compensable. So the claimant here has established a compensable accident. Now, there's the second prong to that, too, that had the fall been the result of an idiopathic condition, the judge in this particular case found there was an increased hazard of employment, specifically the sloping concrete sidewalk that increased the risk of injury. And that is what the judge found that the claimant fell on. So even though they haven't challenged the lack of idiopathic finding by the judge, had the judge so found, this accident is still compensable because of the fall on the concrete sidewalk, which the judge specifically found to be an increased hazard. Now, getting to the next point, did the claimant establish that the accident was a major contributing cause of his right upper extremity injury? And clearly the claimant has. As the court's already noted, the employer carrier in their legal memorandum also stated as a result of the accident, claimant sustained a 3-part fracture of the proximal humerus, which was repaired by Dr. Cole. Their adjuster in her deposition testified that as a result of the fall, the claimant broke his shoulder in 2 places, I think is what she said. The evidence in this case establishes that the claimant had no previous problems with his right upper extremity or right shoulder. There was no pre-existing idiopathic conditions there. He fell. The fall was witnessed. Fell on his right arm and shoulder. immediately complained of pain, among other places, in the right arm and shoulder. When he was being taken by ambulance to the hospital, he complained of pain in the right arm and shoulder. When he got to the hospital, they took x-rays which documented the fracture and documented that he sustained an injury.
Counsel, pardon me, at what point did the claimant put on medical evidence that the major contributing cause of the injury was the fall?
Well, the statute, there's not testimony in this record that's where a doctor says, I state that the fall was the major contributing cause of the right shoulder injury. First of all, you don't need the magic words. There's cases that say that. The statute says establishment of the causal relationship between a compensable accident and injuries for conditions that are not readily observable must be by medical evidence only, as demonstrated by physical examination findings or diagnostic testing. Major contributing cause must be demonstrated by medical evidence only. It doesn't say medical testimony, I might point out, but in this case, in addition to their admissions, you've got the fall, you've got immediately thereafter the diagnosis of the right upper extremity fracture. There's no other cause that's been presented for the injury to the right shoulder. In fact, the judge made a finding in this case the claimant didn't even need to prove major contributing cause based on Lanham versus Department of Environmental Protection. And in that case, the court stated, which was a fall, the lady there fell on a sidewalk and injured her wrist and hip and so forth. And the court in that case said, in that the record discloses there was only one cause of claimant's injuries rather than competing causes, claimant was not required to present additional evidence going to the issue of whether the work-related accident was a major contributing cause of the injuries. Now, granted, that's a pre-October 1st, 2003 case, if that makes any difference, but that's what the court said in that particular case, and that was one of the grounds that the judge relied on initially in his order. But we would submit, back to your question, Judge Rowe, is the combination of the claimant's fall, no pre-existing problems with his shoulder, taken to the hospital, immediate evidence of injury to the right shoulder, x-rays demonstrating the shoulder, surgery on the right shoulder, all authorized and approved by the employer carrier, plus their statement, the adjuster's statement that he injured his shoulder, and their memorandum so stating, certainly constitutes competent evidence to establish that the fall was a major contributing cause of the injury. I like what the judge said here in his final judgment. I mean, he says, I find that the judge of compensation claims would have to completely suspend common sense and belief not to make the clear causal link between the fall and the fracture from the medical records and evidence. So we feel that the claimant has clearly established the causal relationship here. On the third point, their argument that the judge erred in directing the employer carrier to authorize ongoing medical care for the right shoulder, they argue that it was beyond the scope of the hearing. At the hearing, the claimant requested physical therapy for the right shoulder. We contend that that has not been properly preserved for appellate review. This court has come out, starting with the Hamilton case last year, has stated that an argument not made before the judge of compensation claims is not properly preserved for appellate review. And the court said if the error first appears in the judge's final order, then it's incumbent upon the party that objects to it to file a motion for rehearing to at least present the issue to the judge of compensation claims. They did not do that. So we submit it was waived. Now, the Arvida case that they cite in their brief does hold to the contrary, but that's a much older case. And it seems to me that the Hamilton case forward, which came out, it was either last year or 2 years ago, is really a change in the court's position on that point. Because it used to be, the older cases used to say that this court will not reverse on appeal a technical error that could have easily or readily, wrong word, but been corrected via motion for rehearing. And it seems like the court has really taken a different position from just requiring a motion for rehearing on small technical errors. It now seems that if there's an error that first appears in the final order, if you want to bring it up here, you need to file a motion for rehearing. Our second position under point 3, as far as the medical treatment, is it's also harmless error, because as long as the claimant has not reached maximum medical improvement, of which there's no evidence in this case he has, he's entitled as a matter of law to remedial treatment for the injury anyway. So we submit the judge's order is based on competent evidence in a court of applicable law, and that it should be affirmed. Thank you.
Thank you.
Judge, in reference to what you read into the record as to a stipulation, that was in a hearing information sheet, which is provided just a couple of days before the hearing. So there doesn't appear to be any suggestion of a sandbagging for that. Number two is it's not a stipulation, because in the judge's order, he even acknowledges that the hearing information sheet, which is submitted, that you read into the record, is simply for argument purposes only. So it's not submitted to the court for a stipulation. Page 92, I believe, is where you read in the record, and the judge's exhibits are identified in his order. It says that is not any evidence in this case. So I would submit that was not a stipulation that would have sandbagged counsel into believing they didn't have to present medical evidence. It's clear they have to present medical evidence. They didn't do it. It's clear they have to present evidence that there's an occupational cause for this gentleman's fall on the job. They simply did not do it. The burden of proof merely was not met in this case, and for that reason, this is not a workers' compensation case for which there should be benefits due and owing. We therefore suggest that this claim should properly be denied based upon this court's review. Also, I would cite this court, the FedEx versus Boynton case. The court should be familiar with this case in reference to the requirement that there must be medical evidence under the post-2003 cases to support a compensable workers' compensation claim. It does not exist here. If you read the FedEx case, it's mandatory. It suggests that it discusses the post-2003 amendment. The Serrano case, I believe, is a very good case that supports our position wholeheartedly. Again, the exertion that gentleman made on the case, the courts found was not enough to make it compensable. In the Lanham case, again, there was a trip on that pavement. In this case, we don't have a trip, slip, fall. We have nothing. So therefore, the Lanham case, which did predate the major contributing cause statute, is not applicable to the case at hand. For those reasons, because the plaintiff has failed to meet their burden of proof, which is mandatory to establish a workers' compensation case, we would ask this court to reverse the JCC's order and deny the benefits. Thank you.
Thank you. Thank you, counsel. Thank you both. That concludes the court's calendar for today. We are adjourned.